Good afternoon. I am Mike Follins. I'm a partner at Tully Rinckey's Austin, Texas office. As Pat stated, I'll be presenting today regarding the informal EEO complaint process. What we'll learn today, as Pat mentioned, is the law that protects you against discrimination, when and how to file an informal EEO complaint, what to expect when filing an informal EEO complaint, how to initiate contact with an EEO counselor, and the ADR stage. So the laws or statutes that protect you against discrimination. First and foremost, that is Title VII of the Civil Rights Act of 1964. This law protects employees against employment discrimination. The categories that are included in this law include race, discrimination, color, national origin, sex, and religion. As noted there, national origin includes ancestry and ethnic characteristics, and sex includes pregnancy and gender stereotyping. As we may get to later, this includes discrimination based on these categories and harassment or hostile work environment based on these categories. Another law that protects against discrimination is the Age Discrimination and Employment Act of 1967. This applies for people that are over the age of 40 and older. Another law that protects against disability is the Rehabilitation Act of 1973. Additional statutes include the Genetic Information Discrimination Act of 2008, includes information about genetic tests and diseases of employees or family members. And then there's a category called retaliation. Retaliation means when an employer takes action against an employee because of protected activity. It's illegal for an employer to take action against an employee because of their protected activity. Protected activity is defined as generally two categories: opposition and participation. The most common type of protected activity is the participation when filing a prior EEO complaint. However, it's not limited to just filing a prior EEO complaint. If you bring a complaint to a supervisor through an verbally or written format, that could also include participation in an EEO complaint. In addition, testifying or being a witness to, providing testimony in an EEO complaint could also be protected EEO activity. And that also goes into the opposition clause. Opposing explicitly or implicitly discrimination or any practice made unlawful under anti-discrimination statutes can be protected activity. So just to be clear here, protected activity is not limited to just a prior filed EEO complaint. It could be a complaint that you inform your supervisor about through email even, or explicitly opposing the discrimination in the workplace. As I mentioned, race and color discrimination is covered by Title VII. Race discrimination involves treating someone different because he or she is of a certain race, or because of personal characteristics associated with race, such as hair, texture, skin color, or certain facial features. Color discrimination involves treating someone different because of their skin color complexion. Importantly, just because a deciding official, management official, supervisor is of the same race as the person bringing a complaint does not preclude liability. There's a very often racial stereotyping that may be assigned to certain members. So long as race is a consideration in the management's action, Title VII applies. Discrimination based on sex. Discrimination based on sex concerns treating someone differently because of that person's sex. Sex discrimination includes discrimination based on gender identity or because of sexual orientation. This also includes sexual harassment, which means harassing somebody based on their sex. This means that if the person is subject to unwelcome sexual advances, or request sexual favors, or other verbal and physical harassment of a sexual nature. Sexual harassment is illegal when it's frequent and severe. And the standard you'll see is severe and pervasive, that it creates a hostile work environment. The other option under sexual harassment when it becomes illegal is when it results in an adverse employment decision, such as when there's a quid pro quo, where an employer will condition harassment based or condition an offer of employment based on sexual favors. The law doesn't prohibit simple teasing or offhand comments or isolated incidents that aren't very serious, but it does prohibit harassment when it's based on protected categories that we've mentioned. Disability. Disability is defined as a physical or mental impairment that substantially limits one or more life activities or having a record of such impairment, such as that impairment appearing in an agency file or document, or having an actual or perceived impairment. That is also included in a disability definition. For a reasonable accommodation, an employer is required to provide a reasonable accommodation to an employee or job applicant unless doing so would cause significant difficulty or expense for the employer. So when an employee requests an accommodation, they're requesting one because, and then the determination is whether the individual can perform the essential functions of the position with or without a reasonable accommodation. When an employer receives the accommodation request, the employer is required to undergo the interactive process and make a good faith effort to determine whether the accommodation can be provided. And that would allow the employee to return to work while performing the essential job functions. An employee could trigger the interactive process by indicating that she needs, or he or she needs a reasonable accommodation, or he or she needs assistance because of a medical condition. The request doesn't need to be in writing. It doesn't even have to include the specific words. If an employer, when they receive a reasonable accommodation request, it is entitled to ask limited medical questions or ask limited medical conditions in response to an accommodation request. As I mentioned, when the employer receives an accommodation request and they go through the interactive process, part of the determination is to determine whether or not the accommodation request constitutes an undue hardship, which means whether the accommodation would cause difficulty or expense for the employer. If the employer is able to establish that it would constitute an undue hardship, it need not provide the accommodation requested. And some factors that employers will consider is the employer's size, financial resources, and nature and structure of operations. Next, religion. Religion has two separate protections. Prohibits discrimination based on religion, and employers are required to provide reasonable accommodations for employees' sincerely held religious beliefs. And again, the exception here is if the accommodation poses an undue hardship on the employer. It's the employer's undue hardship analysis is similar to what we just discussed for the for the disability analysis is those factors, those financial considerations, and whether there's going to place a significant difficulty on the employer. But those are the two general categories for protection of religious discrimination areas. So as far as filing an EEO complaint, what you need to know and what steps to consider. First, you need to know the basis of your discrimination claims. You need to be able to convey to the EEO office why you believe you've been discriminated against, based on some of the categories we went over already today. You also need to understand that the EEO office has jurisdiction only over discrimination claims. Claims regarding a supervisor's treatment that is similar to other employees' treatment is not going to be protected. You have to prove that there was a differential treatment. You also need to familiarize yourself with what you need in order to establish and successfully prove your discrimination claim. What you need is usually evidence, supporting your discrimination claim to prove that you've been treated differently. As far as filing an informal complaint, so the initial process for federal employees is to file an informal complaint of discrimination. This is called the informal stage. How you do that as a federal employee is you contact your EEO counselor. Your agency should have an EEO office who employs EEO counselors to receive EEO complaints. These EEO complaints must be received within 45 days of when the discriminatory act took place. The exception there is if you find out after the discriminatory act took place, the deadline does run from when you found out of the discriminatory act. When you contact the EEO counselor, you have to describe the discriminatory act in detail and describe why you believe the action was discriminatory. Most agencies will receive EEO complaints via telephone or via email, and that contact information can usually be found on the agency's EEO website. Again, when you're contacting the EEO counselor, you should understand why you feel you're being discriminated against and assert to the counselor the basis of your discrimination. On the next slide, we provide more detail on what the meeting with the EEO counselor entails. That initial meeting with the EEO counselor, you'll discuss your claims, and then the EEO counselor will go over the process. The two general processes are the traditional counseling, or there's requesting ADR. The traditional counseling process is a 30-day period. That means 30 days from when you initiated contact. And the counselor will likely respond and tell you when the date they are counting for initiating contact. That EEO counselor is a neutral person who will speak with yourself regarding your claims, and then we'll speak with management regarding the responses to your claims. Under this traditional process, the counselor will interview you and interview management. And then after the end of the 30-day process, the counselor will issue a counseling report and provide you your options to file a formal complaint. Importantly, the counselor is not there to make any findings or speak on behalf of the agency. The counselor is there to receive your concerns, your complaints, speak with management to get their responses and report that back to you. The other option is the ADR process, and that is participating in an alternative dispute resolution ADR program, such as a mediation, to resolve your complaint. If you elect to participate in this ADR process, the process extends to 90 days. That means 90 days from when you initiated the EEO contact. The agency will appoint a mediator and schedule the mediation. At the mediation, you would participate along with an agency official who could respond on behalf of the agency to your claims, and as well as the mediator. The goal of the mediation is to resolve your complaints during that ADR process. If the dispute is not resolved through the counseling, the traditional counseling, or the ADR process, then you can move on to the formal complaint stage. The counselor will advise and provide a notice to you saying that if the case doesn't resolve, they'll provide a notice to you saying that the formal complaint can be filed within 15 days of receiving the notice of right to file. And they'll also say in that notice that the informal complaint period is over. We will likely have a future session regarding the formal complaint process, moving on with that process. But as far as the informal complaint process, that is the procedure. Some of the questions we received pre-submitted, and I do see that there's been some questions received here. I'll go over the pre-submitted questions first. When should I obtain legal assistance, and what are the next steps for that process? Well, that is the employee's choice. Because of the specific deadlines and because of the process that, the different options, you could obtain assistance before filing the EEO complaint. However, if you want legal assistance filing it, be sure to obtain legal assistance before your deadlines have come. As a reminder, you have 45 days to initiate an EEO complaint from the date of the action or the date you became aware of the action. What type of language should be used in an EEO filing? When you file an EEO complaint, you have to provide the basis of the discrimination, the race, color, sex, national origin, religion, disability, or age, why you believe you've been discriminated against, who you believe discriminated against you, when the discrimination occurred. Again, that's important because there are certain deadlines in place, and what you're seeking for relief in your complaint. You should convey to the counselor, well, this is why I feel I've been discriminated against. This is when it occurred. This is who did it. Then this is what I want. This is what I want to resolve it. What happens after your informal complaint has been filed, and how long do I wait? As discussed, there's a traditional process and there's an ADR process. After your informal complaint has been filed, the EEO counselor under the traditional process will contact management to obtain responses to your claims. If you elect the ADR process, then they will attempt to schedule a mediation. Again, that could take about 90 days. There's a deadline of 90 days for them to schedule a mediation. How successful is mediation? Mediation can be successful if the employee and the employer are willing to discuss the claims and come to a resolution. The mediation it has been successful for many employees. It of course differs on the type of complaint and what the employee wants and what the employer wants to provide. But mediation would certainly be productive to help resolve ongoing issues between employees and supervisors or management officials. What relevant laws are for prospective employees discriminated based on age for employment opportunities? The key law there is the Age Discrimination in Employment Act that prohibits discrimination against employees over the age of 40. And then what is the next step when an employee is retaliated against for filing an EEO complaint? Well, that person should contact the EEO counselor to advise the counselor that they've been retaliated against. Again, that complaint should be initiated within 45 days of when that retaliation occurred. One of the questions I've received during this chat was, would violating any type of leave under the Federal Medical Leave Act fall under the EEO process? If that means the Family Medical Leave Act, FMLA, technically, no. The EEO process does not have jurisdiction over the FMLA. The exception there is if you connect the FMLA claims to the categories we discussed, then it could fall under this jurisdiction. So, for example, if you say, well, my FMLA was denied, the EEOC is going to say, or the EEO office is going to say, we don't have jurisdiction. However, if you go to the EEO office and say, well, my application, my FMLA was denied, however, somebody of a different race was accepted, then the EEO would have jurisdiction. Does the EEO counselor, another question, does the EEO counselor work with the organization or another entity? So technically the EEO counselor is considered an agency employee. However, they're obliged to remain neutral. That's part of their job description. Their goal and their position is to help resolve claims. So while they are employed by the agency, they're not defending the agency. What if you have a reasonable accommodation and it's been violated? What if you're flatly denied a reasonable accommodation? What rights do you have? So as far as reasonable accommodation is concerned, if you already have an approved accommodation, but it's interfered with, that could still constitute a violation of the Reasonable Accommodation Act. In that situation, outside of telling your supervisors or whatnot that your accommodation has been violated, you could also bring this claim to the EEO office. If you're flatly denied an accommodation, that's another claim you could bring to the EEO office. Sometimes agencies have their own internal procedure where you could request reconsideration of the denial and have a higher level review. You could undertake that process and go to the EEO office at the same time. So I have another question here regarding the reasonable accommodations and understanding regarding pregnant women may request and be approved for reasonable accommodation. So for pregnant women, and federal employees can request FMLA. That was what I mentioned earlier as far as what pregnant women usually do. As far as requesting a reasonable accommodation, that can be requested as well. Yes, they can be approved for a reasonable accommodation. However, what pregnant women usually do is request FMLA. It's typically approved, and if not, there are steps that could be filed regarding Pregnancy Discrimination Act claims. And pregnancy discrimination, there's a law called the Pregnancy Discrimination Act that is related to the sex discrimination issues that we mentioned earlier, that makes it unlawful for employers to discriminate against individuals who are pregnant, or who were pregnant, or who are planning to have a baby. Otherwise, those are the questions that I believe I've received here during this presentation. Again, we do plan on having another presentation regarding the formal complaint side. Otherwise, thank you for attending today's presentation.